All right, so this week we're going to look at this concept of context, which is referred to in the materials. Context, I suppose, and purpose. So we've obviously touched upon purpose before because we've been looking at the acts interpretation, acts, plural. But context is a slightly different look at it. That is that we look at a specific provision. How then do we interpret it? Is that provision coloured in some way by the other provisions that are in the same section of the Act, or by the Act as a whole, or other things? So it's this idea that we consider the text of legislation in isolation, and then we also will consider it in a contextual way. And of course, purpose is part of that. But purpose, I think, is a little bit different because it focuses upon things external to the Act. It looks at Hansard, the second reading speech. It looks at explanatory memoranda, singular. It looks at extrinsic materials, whereas context looks at the Act as a whole and then sees how that fits together. So I've just been saying that. Obviously, context is we look at the parts of the Act that precede and follow. We look at the heading, we look at the other sections in that relevant chapter or part, and then we give that section some meaning by virtue of those other sections. Purpose, we look at the objects. We're looking at the object of the Act, and we're doing that often by looking at extrinsic materials. Preferred construction as a phrase is about promoting the purpose or the object that underlies the Act. You might remember last week we were talking about, I think I used the example of the tax legislation, that once the purpose rule came into the Acts Interpretation Act, the whole context of the tax legislation changed. The purpose is to generate revenue, and once you've got that as the underlying purpose, the interpretation of specific provisions will favour the tax officer's interpretation rather than the individual taxpayer's interpretation. Best achievement approach is this idea that prefers the interpretation that would best achieve the purpose or object of the Act to any other interpretation. It's not just a common law concept. It's not just judges saying that. It's been dictated to us or to the judiciary in the way that they interpret legislation by the Acts Interpretation Acts. Ordinary meaning, plain meaning, literal meaning, that sort of phraseology is that it just means that we read a section and we look at the ordinary meaning of the words. We don't try and create a legal meaning, or we don't try and give it some meaning that refers to the custom in a profession or the trade usage in a profession or some type of technical meaning. We read the words and we say, what would a reasonable person read if they were reading these words? And we don't then also try to interpret it based upon what the Act might have said in the past, or what an old version of the Act might have said, or what a judge has said. We just focus upon the reading of the words as they are. So obviously that's a great starting point in interpreting the legislation, because it doesn't require us to do anything other than a reasonable person walking down the street would do in the way that they treat the legislation. The English judges used to talk about the reasonable man on the Clapham omnibus. So what would a reasonable person sitting on a bus think if you showed them this Act and you asked them to interpret it? In other words, the written expression of the words on the page is the key determining factor. And obviously in the text, in your text, they use this methodology, if we call it that. Read the provision and gain a sense of the ordinary meaning. Then look at the underlying purpose of that section, or the sections or the Act in context. Consider the intention of the section. What's the section trying to do? Is it trying to stop someone putting chemical waste into a gutter? Is it trying to stop someone offending in some way? Is it trying to set up a tribunal or set up some type of mechanism? What's it trying to achieve? What's its intention? And then assess if the meaning, return then to the provision and just read it again and say, well, how does the context and the purpose and the intention, how does that, if at all, change the ordinary meaning of the words in the section? This idea of best achievement approach or preferred construction approach, they really come from the Acts Interpretation Act provisions. That is 15AA in the Commonwealth Act. In interpreting a provision of an act, the interpretation that would best achieve the purpose or object of the act. And I mean, as I said to you earlier, I think the tax legislation is an excellent example of that. But the Queensland provision is very similar to the Commonwealth one. The New South Wales one is a little bit different. It says the interpretation of a provision of an act or a statutory rule. So suddenly they've already changed the dynamic there because they're saying it's not just about an act, it's about rules and regulations as well as acts. A construction that would promote the purpose or object underlying the act or statutory rule, whether or not that purpose or object is expressly stated in the act. Now that's quite extraordinary because it's saying even if there isn't an objects clause or a purpose clause at the beginning of the act, you need to effectively read it in to the act and go a step further. So you can see that's going a step further. That is the New South Wales legislation. It goes a step further than the Queensland and the Commonwealth, this is the Commonwealth Act here, goes in terms of this purpose rule. So I think all you need to take out of that is that the New South Wales legislation is a little bit more robust, a little bit more a little bit more definitive in the way that it articulates what you need to do as a reader of the legislation. So there is a bit of difference in the language between the two approaches. They are different approaches. Don't think that they're the same. The New South Wales one is a broader approach. It's a best achievement approach rather than a purpose approach, and that's the way it's been defined. So just I think know the difference between best achievement approach and purpose approach. Purpose, Queensland, Commonwealth, best achievement, New South Wales, and some of the other Australian jurisdictions. So preferred construction is the next heading there. This is the idea that there could be a number of constructions available to someone reading a different act. I think you'll find that last semester this case was on the assignment, and obviously this semester Trevisan, which is here, is one of the cases on your assignment. To prefer one construction to another can only have the meaning where two constructions are otherwise open. Whereas in Birch they said the section does not state that the purpose or object may only be considered where the provision being construed is reasonably open to more than one construction. So there are the preferred construction approach. It requires that there be two potential constructions available. And if there are not two choices, it would not be possible to prefer one over the other. The two views are the views expressed on one hand in Trevisan and on the other hand in Birch. So this is obviously very relevant as to the analysis that you're currently doing in your assignment. So Justice Kirby, or former Justice Kirby, mentions in your textbook, he talks in this case Marquette. He said that in real life there will rarely be one uncontroversially clear public meaning. That case, it's an interesting case, that case of Marquette. And it's interesting, I think, in terms of this subject, because in that case, what was happening was that there was a challenge made judicially. So a party went to the courts and tried to challenge the Western Australian Parliament from presenting an act which they'd passed to the governor, the then governor of Western Australia, for royal assent. So they were trying to stop legislation which had validly passed through the Parliament from becoming law. And obviously this comment by Justice Kirby was made in the High Court in the context of that case, which then went up to the High Court. So there'll rarely be one uncontroversially clear public meaning. So this idea of preferred construction is to say, well, look, there's going to be, if you show a passage of legislation to someone in the street, in fact, the reality is that if you show it to one person, they'll prefer one type of meaning. And if you show it to another person, they'll prefer another type of meaning. And obviously that's the challenge, that judges will need to then interpret what does it really mean, having regard to all these mechanisms that we can use to assist that process. So how do you compare the different approaches? Well, in this High Court decision in Chugg and Pacific Dunlop, they were interpreting a Victorian statute. They were using the Victorian Acts Interpretation Act, and they were looking at a Victorian statute. And the court was seeking to determine the meaning of the qualification to provide a safe system of work. So this is this idea that when any of us are in the workplace, there are requirements upon our employer, whether our employer is a company or a trust or a partnership or a sole trader, howsoever described, there are responsibilities upon our employer to provide a safe system of work. And they were looking at one of the provisions in the Victorian Workplace Health and Safety Act or legislation. And they were asking, what's the meaning of these words, so far as is practicable? Now, you'd think, well, there's a little bit of common sense to what those words might mean, but they were saying, well, look, one reading of it is that may have given an employer a defence in the circumstances. The informant, the work inspector argued, so another party to the proceeding argued that the court should prefer the interpretation which would provide the object or achieve the object of providing a safe workplace. And the court said, well, this is the High Court, said the choice created by the Interpretation of Legislation Act, which is the Victorian equivalent of the Acts Interpretation Act, is not as to the construction which will best achieve the object of the Act. It's a limited choice between a construction that would promote the purpose and another that does not. So that's all quite complicated, but all it's saying is this: the Victorian Act is very similar to the Queensland Act. It's focused upon purpose and object, and it's not about this best achievement rule. That's the New South Wales rule. And so the High Court was saying when you look at the Victorian Act, you see it's just a choice between purpose or not. When you look at the New South Wales Act, it's a different test. It's a broader test. It's the best achievement test. And the authors of your textbook, they say, does the new Section 15AA in the Commonwealth Act, is it a best achievement test or is it a purpose or object test? Well, if you look at it, as we did before, you can see it's just a purpose or object test. It's not a best achievement test. So there's a simple answer to that. It's not like the New South Wales legislation. It's quite a clear balance between purpose and object or not. So there's this historical development. I mean, they use the exact. So when I say historical development, that's what they're saying when they talk about this context. I mean, I think that context, one of the best ways to look at context. Can you see my screen now?
Just see you.
Just see me.
Yeah.
What about now?
Yes.
Okay.
Yeah, screen.
They talk here about the engineer's case, but I think another good example is there's a case called the Duke of Westminster and the Internal Revenue Commission. It's a 1920s House of Lords decision. And quite simply, the Duke of Westminster owned most of central London, and I think his grandson now still does. And he would rent out or lease out those areas in central London and consequently had a huge revenue stream. The context of that case was the case went all the way to the House of Lords about a very simple provision in one of the pieces of legislation. And of course, the result, if it went in favour of the Duke of Westminster, would mean that he would have a huge difference in his revenue by virtue of this provision. And if it went in favour of the state or the Crown, it would go against him. And the House of Lords had to interpret this provision, and they used the literal rule, and they said, well, where there's uncertainty, we're going to favour the Duke of Westminster because there isn't certainty, there isn't some underlying purpose. And what I think your notes are saying is exactly that in the 1920s and 1930s, there had been a very strong literalism in the interpretation of statutory provisions. And over time, we've moved away from that as a society. We're now focusing upon the legislature has effectively increased its power. And the first articulation of that is that if you look at the Australian statutes, or the Queensland statutes, in 1910, there might have been 30 statutes in Queensland. Now, if you buy all of the statutory materials in Queensland, it will fill a wall 4 metres by 4 metres wide and 2.5 metres high. So there's now a huge amount of statutory material at both the state and Commonwealth level. And of course, that provides more power to the legislature because they are dictating to us more and more how they want us to deal with things. And not only are they dictating to us how they want us to deal with things, they're telling us that you must focus upon the purpose of that legislation and the object of that legislation in interpreting what it means. And that's really what this is saying. It's saying that there has been literalism in the past, but now there's a move towards, obviously there's a move towards plain English drafting, but the focus is on the purpose of the legislation, the object of the legislation. And they use as an example the High Court decision in the 1920s. What they're focusing on there, or the reason interpretation's relevant there, is that it was interpreting the key section in the Constitution, key section being Section 51, and all the powers given to the legislature in Section 51. And the engineer's case became very important. You might remember when work choices went to the High Court. I'm thinking that was in about 2006, because it was a similar type of case. It was an interpretation of the Commonwealth's legislative power. Okay. So the context today, well, obviously things have changed. Now you don't just look at the individual section. You look towards the context of the words in a section and look at that in a broader context, the context of the Act as a whole, which is context, and then the broader context, which is purpose, object, the object of the act, and the object generally. How do we find the object generally? We look to the explanatory memoranda, we look to the second reading speech, etc. So what does context include? It does include the history of the legislation. I recall looking at some legislation relating to native title matters, and as part of the history of the individual sections, we tracked back all the way back to, I think my recollection is that it was an 1890 Queensland Act, which was called something strange like the Opium and Aboriginals Act 1891 or something like that, or 1890. And I remember being firstly quite surprised about the mixture of the fact that it dealt with laws relating to Aboriginals, but also that it was dealing with laws relating to a drug or drugs. So you look at the circumstances in which the Act was written or passed and the time and place of writing. What was going on contextually at that time? I mean, some of these things have been quite significant because, for example, when there's an interpretation going on as to some of the security legislation that was passed in that post-September 11, 2001 period, or some of the legislation as to the Migration Act or the Customs Act and powers that are given to customs officials or migration officials, and how that might change the context. So you can see how some of those things have real, what's going on in the world will obviously have some potential relevance. The High Court has endorsed the adoption of the widest possible meaning to include such things as the existing state of the law and the mischief by legitimate means one may discern the statute was intended to remedy. And I think this is a good summary, not just of how they're interpreting things, but as to how the High Court is working as a constitutional court. They have spent the last 100 years expanding the power of the Commonwealth and expanding the legislative power of the Commonwealth. So they've been effectively saying we're going to give the Commonwealth's legislative powers, which are in Section 51 of the Commonwealth Constitution, we're going to give those legislative powers the widest possible meaning. So I think that's a very fair statement there as to what has been occurring. And if you track back through the High Court decisions, that's exactly what they did. And we just mentioned the engineers case, but the work choices legislation is an example of that. That is that it was challenged in the High Court. Remember, the work choices legislation used the company power to pass legislation about the employment rights between workers and employers, or employees and employers. So it was giving a very broad, wide interpretation to a very specific provision in the Commonwealth Constitution. They mentioned this case, CIC Insurance and Bankstown Football Club Limited. The High Court of Australia was concerned with the meaning of a provision in the Insurance Contracts Act 1984, which required an insurer to give a notice to an insured of an intention not to renew their current policy. There'd been a number of fires at the club, one of which they thought had been deliberately lit by the president or some member of the club. And the High Court said, well, it's well settled in the common law, so they're looking to case law to help them work out the answer. And then it's mentioned in the Acts Interpretation Act that the court may have regard to reports of law reform bodies to work out what's the mischief which the statute is trying to fix, to cure. And so they're really articulating how is it that we're going to work out the answer to this. We're going to look at cases that have been passed or determined before. We're going to look at the Acts Interpretation Act. We're also going to look at some other extrinsic materials. They mention extrinsic materials written by law reform bodies. So the High Court took the view that context is very important. Look at the immediate context within the Act, and then look at other intrinsic and extrinsic materials that are relevant. Look at the broader context, history, the circumstances when it was passed. Look at government policy. I mean, I think it's a very challenging thing to do this, but of course it's been made a lot easier by the internet. If you think back to even 1995, things started to change by about 1998. But as recently as, say, 1995, although it feels like yesterday for me, it probably feels like a long time ago for you, but the ability to identify a lot of these additional documents and materials and what was going on at the time. I mean, the fact now that even all of the newspapers are online has made a lot of this stuff a lot easier to identify. Even to identify international law now, far easier. To find, for example, the Australian Treaty Series in 1995, you would have spent a fair bit of time in a university library or in a state library trying to find those types of documents, and then to make sure you had the relevant ones and then to analyse them. So it was a very time-consuming process, but of course now it's nowhere near as difficult. And I do think that the ability to do this contextual analysis has been improved greatly by the internet. So when can context be considered? From that CIC insurance case, you can see that the High Court takes the approach that context needs to be considered at all times. I mean, obviously, for the High Court to say that when they did, which was 1997, I think that's a real reflection also of the change which occurred in that court in the way they were dealing with things. That's before the internet really took hold of everyone, but they had the ability at that time to do that type of analysis, of course. Utility, not necessity, is the reason for reference to context. So it's not that we need to do it, it's that we should do it. We should be doing it as part of the process. And you can see they've really followed that process. Context should be considered in the first instance, so do it as part of the initial analysis of a case. And there's a 2005 decision there, which is a criminal decision, an appeal to the High Court from the Court of Criminal Appeal New South Wales. They looked at the division in which the relevant section sat. So they were looking at all the other sections in that part. They looked at the common law as to the question. So if it was a homicide case, they looked at all the previous cases, maybe not just in New South Wales, but in other jurisdictions, and they looked at the history of the legislation. I mean, I think it doesn't emphasise it there, but one of the things the High Court now look for is an analysis of how similar provisions, so let's say if you're looking at a Queensland section, how have similar provisions in other states and overseas been dealt with? I mean, of course, it'd be nice to think that we've got brilliant people in Queensland who are writing and preparing lots of pieces of legislation, but the reality is that legislation, for the most part, is copied. In Australia, we tend to copy legislation that comes from New Zealand and or England and or Canada, and those jurisdictions tend to copy legislation that's come out of the American states, because out of the 50 or so states in the United States, their ability, just through the volume of legislators and the wealth there, their ability to generate new legislation and new ideas, and then for that to be copied by other jurisdictions, and then, of course, for the Australian jurisdictions to copy it as well. So purpose, we've obviously been talking a lot about purpose, but we should just spend some more time focusing upon the mischief rule. The textbook describes the modern purpose approach as being more than what we used to call the mischief rule. I think in 1991, when I first did Introduction to Law, that is when I first did statutory interpretation, which was part of that subject at the university then, the purpose rule was the new rule. It was very much, and it wasn't such a clear dominant rule that it is today. At that time, we really learnt the mischief rule as being one of the key rules rather than the old rule in the way we learn it today. The mischief rule stated that interpretation required us to determine the manner in which the legislation intended to deal with the mischief. So what was the problem, and how was the legislation trying to solve that problem? So what was the law before the Act was passed? What were they trying to do? Was there a problem with, dare I say it, was there a problem with some type of criminal element in society? And was Parliament then focusing upon that issue and passing an act or acts relating to that? Or was it that there'd been a long, drawn-out fight about the issue of a consumption tax in Australia between both sides of politics, and then there was an election in 1998, and then there was the passing of the GST legislation? And was the mischief? Well, the mischief was that they wanted to tax consumption rather than and reduce the income tax levels. And so that's a mischief, but it's a positive mischief as such, if you think of it in that context. And how did Parliament fix it? Well, the Commonwealth Parliament in 1999, I'm just using this as an example, passed a series of acts called the A New Tax System, GST Act, the GST legislation. And so that's a positive example of mischief, rather than just thinking of it as we want to stop criminal organisations, or we want to stop something else. Consider the difference between the approach and the approach of interpretation legislation. The textbook authors, obviously there's a difference between mischief and purpose. And that, it creates a different outcome potentially. Here's a copy, obviously, of the Queensland provision. And as we said before, we weren't looking at this one, but if you look at that, section 14 capital A, subsection 1, best achieve the purpose of the Act. You'll notice it doesn't even mention object. And you'll see that's very, very similar to, way up here, the Commonwealth Acts Interpretation Act. But it doesn't mention object in the Queensland one, but different from the New South Wales provision. All right. So finding the purpose of an act, well, and this is a good example, you often go to the start of the act where they might have a preamble or an object or a purposes clause or some type of overarching statement about what is this act really supposed to achieve. And this one, it just says the primary object of this act is to provide for the fair collection and handling in the public sector environment of personal information. So that's the way you'd say that, is it's section 3, subsection 1, paragraph A. The heading is the object of the act. Subsection 1, the primary object, is to provide for paragraph A and paragraph B. And it's always helpful to consider that object. I think the hardest thing I find now is not trying to interpret a specific provision, but it is trying to find the relevant provisions. That is, that when you go to the Queensland Office of Parliamentary Counsel website, as I'm doing now, although you can't probably see it. Can you see that? No. when you go to the Queensland Office of Parliamentary Counsel website, sometimes it's very difficult. Like, if, for example, I was talking to someone the other day, and I was saying you need to have a look for the Uniform Civil Procedure Rules, which are the rules for how you operate in the courts, and you need to check whether they have a rule about something. I can't recall what we were looking at. And of course, the next question was, I've looked under U and those rules aren't there. The rules are under S for Supreme Court. So it's an unusual scenario whereby sometimes you will check specific things and you won't actually find the relevant act. And I think that's often more of a challenge now than interpreting the provisions in the act once you've found the right act. Finding out the law is very difficult. And it's not easy. For example, if I said to you, can you find the relevant provision or provisions that prevent me from pouring a chemical down a gutter in Queensland? I suspect it would take nearly an hour to articulate in an email what those provisions are. It's not an easy task. And you'd think it would be a lot easier than that, but you've got to find the relevant act. Sometimes you've got to then track through the relevant regulations. You've got to then work out where in the act the specific provisions are, and then you've got to, work out the mechanism. All right. I'm just going to jump through this section because it's just about the idea that acts and purposes will either be articulated, normally they'll be articulated in a Queensland Act, and normally they'll be articulated in a Commonwealth Act. Of course, there's been a lot of discussion recently, and I was talking to someone just today about the Commonwealth Constitution, and there's been this discussion about a potential preamble to the Constitution and how that might, in an interpretation sense, change the interpretation of specific provisions in the Constitution. So looking at an overview of purpose, this is what the textbook suggests as being the way of determining. If there's one purpose and one meaning, check the meaning that promotes that purpose, and take into account the context. Context being where in the act is that section, what division's it in, what chapter's it in, what part's it in, however so described. If there's more than one meaning but only one purpose, choose the meaning that promotes the best purpose. If there's more than one possible meaning and multiple purposes, select the dominant purpose. I have to say that I think this is complicating something which isn't that complicated. To me, when I read through this, and when I read through it for the first time, I thought to myself, that makes it sound so much harder than it really is. I'm reading something and I'm asking...
Sorry, can I just interrupt? I'm getting an awful lot of interference on sound.
It seems to have gone away now, hopefully. Well, now it's back.
No, I'm still getting it. I've got to go now. I've got another appointment, but I'll look at the recording later.
No worries. Thanks, John.
Thanks.
Yeah. Can everybody mute their mic, please, just to see if it stops the noise? How's that?
So much better.
It seems to be better. Thanks. Okay, so I was just talking about this flowchart here, and I think it actually makes it more complicated than it needs to be. But you can see what they're trying to do. They're trying to structure the way, or they're trying to give us a real methodology. It's quite it's a classic academic thing to do. That is to to take something which judges do in a very simple way, which is they do what you and I do. That is, they look at the provision, they find out what's been said about that provision by others, whether it's other judges, whether it's the Parliament, whether it's the executive through their departments, if there's some departmental commentary on it. They bring all that information together and they apply it to a set of facts. And this is I think that's what they're saying here, but they're saying it in quite a complicated way. All right. So we've looked at these ideas of context and purpose. To summarise, I think it's not as complicated as it sounds. It's about looking at a section and then taking that section and surrounding it, as I was just saying, with all the other information we can find about that section. And when you do that, it obviously puts a bright beam on the section and gives us a clearer idea of what the section means. And thankfully in Queensland we have a nice, what I would describe as a nice, simple interpretation section that says, what's the purpose? Whatever the purpose of that section is, follow it. Whatever the purpose of that act is, follow it. I think the New South Wales one is far more complicated and requires us to take another step or series of steps that we don't thankfully have to do in Queensland. Right, so let's just have a look at these questions. And I'm gonna start hitting you guys up because I've been talking for too long already. When there are a number of possible purposes in an act, what's the preferred approach to interpretation? Michelle?
Dominant purpose.
Dominant purpose. Look for the common theme, look for the dominant purpose, determine the most used theme, ignore the purpose altogether. I agree, dominant purpose. That's pretty. What did Gleeson CJ say that parliaments could do when the courts fail to interpret their laws correctly? Remove the offending judges, provide better guidance, provide examples in the Act, or amend the legislation. Jessica? No? What did he say? I'm thinking he'd say that one. Is that right?
D.
Amend the legislation.
Yeah.
It doesn't sound like Chief Justice Gleeson, but I'll believe it if that's what he said. I recall him once in the court. He said it was a case about a shopping centre in Serena, up near in northern Queensland, and the case was going on, and he kept leaning forwards and he kept saying things like, well, why does it matter? That what had happened in that case was that a valuer had valued the shopping centre too high, and the shopping centre obviously dropped in value very quickly. And he said, well, why does it matter? I mean, the valuer values the shopping centre too high. What happens? What would have happened if there was a cyclone the next day? What would have happened if there was a flood? What would have happened if there was a fire, a bushfire or something? Why are we blaming the valuer? Why do we have all these? That was what I thought of when I read, what would Gleeson say about how we interpret the laws correctly. He was a very, very clear-thinking individual in the way he was a judge. That is, he focused on what's the answer I need to give, and I'm just going to give that answer. Question 3, when there is more than one meaning but only one purpose in legislation, what's the best approach to take? A, select the dominant meaning. B, align the purpose with the meaning. C, select the meaning that promotes or achieves the best purpose or the purpose. Or D, consider the context. Shelley?
I'd say C.
Select the, and you're not just picking that because it's the longest one, I hope.
I remember that trick from the test.
Yeah. That was the discussion last week. What does it say down below? C?
I don't know.
Promotes or achieves the best purpose, yeah. All right. 4, why do we consider words not in isolation but in context in statutory interpretation? A, the courts promote this approach. B, the literal approach has been discredited. C, this is how we usually speak and understand the meaning of words. And D, this approach gives us an all-round meaning. Jessica. Not there. What do you think? Why do we consider words not in isolation but in context in statutory interpretation? It's not A. Literal approach has been discredited. Well, it's not really B. The literal approach hasn't been discredited. It's just we must focus on the purpose approach. It's not C. Really, it's more D, I think. Let's have a look.
I was thinking it was C because of the plain English movement.
This is how we usually speak and understand the meaning of words. Not in isolation, but in context. I can see why they're saying that, but I think it's this one, isn't it? My view is I would have said this one because I'm saying we're looking to ensure that we're getting the reasonable person's perspective on interpretation. That we're not. The danger is as we get trained, we become different in the way we interpret. And in fact, by learning this subject, we're immediately, what are we doing? We're considering statutory materials in isolation, and we're not having an all-round meaning that you understand my point anyway. Question 5, what was the name of the case which dealt with finding the meaning of punishable homicide through consideration of the surrounding context? Well, the only criminal case there is the Crown and Lavender, so that's the one, isn't it? Question 6.
Always R.
Yeah.
R and 2. Why is it R?
R's for Regina, for the Crown.
That's
so
strange. Regina.
Yeah, well, the Queen in Latin is Regina.
Okay, right.
The King is Rex, R-E-X. So R is just the shortened of.
Okay, so
because
it's essentially Queen and Lavender.
Yeah, the Crown is taking the action against us as an individual.
Right, got it.
In the engineers.
So
Sorry?
where it's got the Queen as one of the parties, is that the same thing or is that a different?
No, it's exactly the same. So it's exactly the same. So you'll see, in fact, you'll see that. You'll see sometimes in older cases, you'll see the Queen against. So in a criminal case, it's against for the V. In a civil case, it's and. So CIC Insurance and Bankstown Football Club, Blue Sky Mining and Garrett. And then the Crown against Lavender or the Queen against Lavender, however so described. In the engineer's case decided in 1920, Higgins made a pronouncement that the fundamental rule of interpretation to which all others are subordinate is that a statute is to be expounded according to the intent of the Parliament that made it. This is said to be a classic statement of which approach to statutory interpretation. Somebody else. Who else we got out here? You're all...
Yes. The literal approach.
Literal approach? Yeah. And remember I was talking about the Duke of Westminster's case, which is about the same time. I think it's Duke of Westminster's, when I say about the same time, it's maybe 1932. But it's in that interwar period, and it's very much the literal period. When the legislature fails to state any purpose in an act, what is the approach of the courts to statutory interpretation? Fails to state any purpose, take a wide open approach. I don't know what that is. Consider the mischief rule. Determine the purpose by consideration of the act as a whole. Well, that sounds pretty good. Consider extrinsic material as a means of determining the purpose. I would have thought the authors would have created this question with D as the answer. Is that right?
Yeah, I would think so too. And if not, that's C.
Yeah. They say C, or which one are we up to? This one?
Yeah.
7.
It could go either way though. Because you can't not look at extrinsic.
You've got to. But, I mean, obviously the first point is look at the act and what's it about. If it's an act to set up a goods and services tax act or something, obviously that's going to identify for the purpose. But if they don't, but that sort of contradicts the question, C, doesn't it? When the legislature fails to state the purpose in the act, well, it mightn't be that clear even by looking at the act as a whole. Question 8, what was the significance of the case which dealt with the White Australia policy? I've never read that case. Crown and Wilson, ex parte, Kish, 1934-52 CLR 234. The long title did not specify the object of the act at all. The long title did not specify what sort of restrictions on immigration the act seeks to achieve. The act was all about promotion of the White Australia policy, but did not openly say so. And both B and C. I would have thought it's B and C. I've never read that legislation.
Like how you say, I've never read it, but I'll have a crack, and I'm going to go with B.
Yeah, well, that's the great thing about multiple choice. 90% of it's just guessing what the way the person's written the question. It's ridiculous, isn't it? Is that the answer?
Yes, it is.
That's just because the two longest ones are B and C, so I had to pick that one, D. Question 9, what was the example given in your text as the best place to find the purpose of legislation outside of the Act itself? To find the purpose of the legislation. It would be this one, wouldn't it?
Yes.
Yeah.
Yeah.
Okay. All right. Well, I'm gonna turn off the recording now. I'm not going anywhere. Just wait a second.